Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in United States versus Palomar-Santiago, certiorari to United States Court of Appeals for the Ninth Circuit. Argued April 27, 2021. Decided May 24, 2021. Respondent Palomar-Santiago, a Mexican national living in the United States, was convicted in California State Court of felony DUI in 1988. At the time, lower courts understood that conviction to be an aggravated felony, subjecting a non-citizen to removal from the United States. That's 8 U.S.C. Section 1227A2 Cap A III. Palomar-Santiago was removed following a hearing before an immigration judge and a waiver of his right to appeal. In 2017, Palomar-Santiago was found in the United States and indicted on one count of unlawful reentry after removal. See Section 1326A. The statute criminalizing unlawful reentry provides that a collateral challenge to the underlying deportation order may proceed only if the non-citizen first demonstrates that any administrative remedies that may have been available were exhausted. Part 2, the opportunity for judicial review was lacking, and 3, the entry of the order was fundamentally unfair. Section 1326D. Palomar-Santiago moved to dismiss the indictment on the ground that his prior removal order was invalid in light of the 2004 holding in Leocal v. Ashcroft. That felony DUI is not an aggravated felony. Following Ninth Circuit precedent, the District Court and Court of Appeals held that Palomar-Santiago was excused from providing the first two requirements of Section 1326D because his felony DUI conviction had not made him removable. The District Court granted the motion to dismiss, and the Ninth Circuit affirmed. The Supreme Court held a decision is reversed and remanded, and Justice Sotomayor delivered the opinion of the unanimous court. Each of the statutory requirements of Section 1326D is mandatory. The Ninth Circuit's interpretation is incompatible with the text of Section 1326D, which provides that defendants charged with unlawful reentry may not challenge their underlying removal orders unless they demonstrate each of three conditions. Section 1326D's first two requirements are not satisfied just because a non-citizen was removed for an offense that should not have rendered him removable. The substantive validity of a removal order is quite distinct from whether the non-citizen exhausted administrative remedies or was deprived of the opportunity for judicial review. Palomar-Santiago's counterarguments are unpersuasive. First, he contends that further administrative review of a removal order is not available for purposes of Section 1326A when a non-citizen will recognize a substantive basis to challenge an immigration judge's conclusion that a prior conviction renders the non-citizen removable. The immigration judge's error on the merits does not excuse the non-citizen's failure to comply with a mandatory exhaustion requirement if further administrative review and then judicial review is, if necessary, could fix that very error. Second, Palomar-Santiago contends, distinguishing Ross, which is 578 U.S. 632. Second, Palomar-Santiago contends that Section 1326D's prerequisites do not apply when a defendant argues that a removal order was substantively invalid. There can be no challenge to or collateral attack on the validity of substantively flawed orders, he reasons, because such orders are invalid when entered. This position ignores the plain meaning of both challenge and collateral attack. Lastly, Palomar-Santiago invokes the canon of constitutional avoidance, but this canon has no application in the absence of statutory ambiguity. That's United States versus Oakland Cannabis Buyers Cooperative. Here, the text of Section 1326D unambiguously forecloses Palomar-Santiago's interpretation. the decision is reversed and remanded. Justice Sotomayor delivered the opinion for a unanimous court. If you'd like to support the podcast, you can find a PayPal link in the show notes. Find me on Patreon. Contact me at roadscholar80@gmail.com. That's ROADS and the number 80. Thanks for listening.